Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is How Was Your Life in Antitrust? A conversation with Jon Jacobson. Today's guest was our very first guest on the very first episode of our Curious Amalgam. Episode 1, Rock Can't Get No Satisfaction, Antitrust, and Rock and Roll. Now, 290 episodes later, we're celebrating the publication of Jon Jacobson's memoir of the highs and lows of litigating some of the biggest antitrust cases in U.S. legal history, and in doing so, helping to shape antitrust law as we know it. The Amazon page for My Life in Antitrust calls it recommended reading for antitrust nerds, but also for those who have no idea how trial lawyers shape U.S. competition policy. As our guest writes in his book, rapid changes in the fundamental law make antitrust amazingly interesting. Before hearing more about that, I'd like to welcome my co-host, Subrata Bhattacharjee. Hi, Subrata.
Hey, Alicia, how are you?
I'm fine. Hey, Subrata, would you like to introduce our guest and kick off the conversation?
I would love to do that. Look, I'm pleased to say that we're here today with Jon Jacobson. Jon is a retired partner from the Wilson Sonsini firm, and as you know, we're going to talk about, he's had a long and distinguished career in antitrust. Apart, I think, from the precedent-setting cases he's worked on that, Alicia, I think you mentioned in the opening, you know, Jon also has made really important contributions to antitrust thought leadership, including work of the Antitrust Modernization Commission, influential articles, and, of course, chairing the antitrust section of the ABA. So welcome back to our Curious Amalgam, Jon.
Very happy to be here.
Let me start, Jon, by asking the obvious question, which is why did you decide to write a memoir at a time when so many of us say, at some point when we sit down, we're going to sort of write down all the great stuff that we've done, but so few of us actually get around to doing it. You have actually done that thing. So why'd you do it?
It came up in dinners that I had at various ABA events, midwinters, post-annuals, and I was sitting with friends and telling war stories, and they seemed fascinated by the war stories. And I had all these saved materials from, my cases from years ago. So it made sense to think about writing a memoir. And then, as retirement got closer, I wanted to have something to do. So hence the memoir. And it was a lot of fun to write.
When I read the book, I think it's not really as much a collection of war stories as I found a very, very interesting explanation of the progression of an antitrust career. And so like that I think is a super interesting part of the book. And I guess one question I had was, when you look back, like what are the biggest differences in antitrust practice between when you started out, I guess, in 1976 and when you retired?
Well, antitrust law has changed dramatically over time. From the 40s, where there was not much antitrust enforcement, in the early 1940s to the late 1940s, where Thurman Arnold came in and had a very aggressive push. So when I started out in 76, we were still coming off of years of Supreme Court precedents that were highly interventionist. But then soon after that, the Sylvania decision came down and other decisions that fundamentally started the process of moving to a consumer welfare standard. And that changed the pro-intervention stance of antitrust enforcement pretty dramatically, to the point where when we got to the 1980s during the Reagan administration, antitrust was quite moribund. So we have that in the 1980s, but then we saw the post-Chicago folks take their position, and particularly in the Eastman Kodak case that I was involved in 1992, we saw a more balanced approach to antitrust law. So we went left to right to middle, and now we're seeing a fairly abrupt change after many years and decades of success under the consumer welfare standard and a general consensus within the bar and the judiciary that that was the way to go. We are seeing highly interventionist actions taken by various states, but more importantly, the Federal Trade Commission and the Department of Justice under Jonathan Cantor and the FTC under Lena. So we've gone sort of full circle in the course of my career from high interventionist to no intervention to middle of the road to now, very interventionist approach. And it's what makes antitrust law so fascinating that you can see the changes in the law as you practice over time. And I think that's been one of the thrills for me in practicing in this field.
So just to pick up on that a bit, Jon, one of the things that you write about in the book is the work you did on the Antitrust Modernization Commission. And I think, and we'll get to this in a bit, I guess you also had the view that the report, had almost no impact. But let me ask you a bit about that. Like when you were working on that, would you have foreseen sort of the position that antitrust is in now?
Absolutely not. We were fending off, right-wing activists and left-wing activists, and we came out with a great report that went down the middle, and which I'm personally quite proud of. It had no impact, and let's look at the reasons for that. So the Antitrust Modernization Commission was the brainchild of Congressman Sensenbrenner. And what he was incensed about was the efforts by the states in the Microsoft case to, get greater relief than was being sought by the Justice Department once Charles James came in. And the upshot of that was that was the central issue that I think at least the Republicans in Congress were concerned about. And then, we started out, and one of the things that, I take some pride in is I didn't think we should divest the states of antitrust enforcement ability, assuming we could even do so constitutionally. So I was a strong proponent of no change to state antitrust enforcement. And although there were some dissents on that prevailed by a large margin in our 12 person commission. But when we did that, when we said no change, that sort of took the air out of the sails behind the push to, quote unquote, modernize antitrust. And the changes that we were proposing were moderate, with one exception. That was, we strongly urged repeal of the Robinson-Patman Act. And then when Deb Garza, who was the chair, went to the Hill to talk with Congressman Dingell about our report and what the next steps were, it was made very clear to Deb that the Robinson-Patman Act was not going to be repealed, which was disappointing because it's a horrible statute.
It's controversial even today, too, as we're seeing a greater push for more government enforcement of the Robinson-Patman Act. Turning back to the highlights of your career, one thing that I noticed was your need to deep dive into certain industries as you were litigating the cases that involve those industries. As I mentioned, our first episode and discussion with you talked about the rock concert venue industry. But your career also has you showing up in important cases in soft drink distribution, healthcare, high tech, and including the representation of Google in more recent years. So of all of these industries, which one was your favorite and why?
So that's a really hard question. I was honored to be able to represent Google, and I was pleased, at the results in the cases we had for Google. I loved representing Clear Channel and later Live Nation in the concert cases. Was thrilled to talk about them in episode 1 of this. But as I think about it, the most rewarding industry for me was carbonated soft drinks and representing the Coca-Cola company. And I had many cases for Coca-Cola, and most of them came out pretty well, and they were great experiences. The people at Coke were terrific to work with. One of them is now a former chair of the section, Brian Henry, but I got to work with a lot of terrific people there, including Deval Patrick, who later became governor of Massachusetts, and just really interesting cases during a period where antitrust was evolving, and just great experiences.
Well, that certainly comes through as you read the book. Now, I think I could probably guess the answer to this one too, as you were talking about the spectrum on which antitrust law has been moving back and forth over the years. Where do you fall?
So I pride myself in being dead center. So I have written papers excoriating the Chicago school. I have written papers excoriating the current move towards, highly interventionist antitrust enforcement. I'm a strong believer in the consumer welfare standard. So on this spectrum, I place myself squarely in the middle. And I'm proud of it. I think that's the place where we should all be, candidly. And the folks on the extremes, I think are pushing the law in either case in the wrong direction.
Jon, let me follow up a bit on that. One of the things that you concluded in your AMC report was that, if I can paraphrase it, that there is no real need to sort of change antitrust law to adapt to particular innovation models or technologies. We are, of course, in a place where maybe jurisdictions outside of North America are looking to sort of sector-specific or technology-specific ways to deal with market conduct. And I'm just curious, sort of, given what you've just said, what your views are on that.
So both on the AMC and in an article I wrote that I think got me appointed to the AMC, actually, Microsoft had been making the argument that tech was too complicated and antitrust should just stay away. And I found that the argument offensive, candidly. And now that we're moving in the opposite direction, I find that approach offensive as well. I do not believe we need different standards, either no intervention or highly intervention. For tech, the consumer welfare standard is flexible enough to deal with new economies and to result in good outcomes if we apply it correctly. So, if we go back to the 1890s when the Sherman Act was first enacted, the railroads all said to the courts that railroad transportation is too important and too complicated, and antitrust should stay away from it. But the very first two decisions by the Supreme Court that enforced the Sherman Act, the Joint Traffic case and the Trans-Missouri case, both rejected that argument. And I think for largely the same reasons, we need to reject it today.
Now, we often like to post articles that our guests have written on the episode webpage, but in your case, that's impossible because you've written so many articles. And as your book describes, you seem to have made it a personal mission to publish at least one article a year on matters of substantive antitrust. How did you do that?
I had been on a journal in law school, and I really got the bug for writing. And it occurred to me when I was starting out that no one knew who I was. No one knew what my views were. I thought I had some pretty significant views. My first article was about contribution among antitrust folks, which I supported and which the Supreme Court rejected 9-0. But I always made sure that I would allocate some time to write something that I thought would be a contribution to the literature. And I forced myself, over time to write on average 1 or 2 articles a year. There were a couple of years where I was just inundated and couldn't do it, but most of the time I would take the time, over the 2,000 plus hours that you tend to be working, and just allocated some time for that. And it took a really long time for my writings to have any impact. I would say 12 to 15 years before they did, but ultimately they did. And whenever I talk to young lawyers starting out, I strongly encourage them to write. It's a good way to understand the issues that you're writing about because you force yourself to do that. And it's a good way to enhance your profile.
So, Sean, where are you telling those younger lawyers to place their thinking? In the same places that you looked at, or elsewhere, other types of platforms?
Well, there are different opportunities today. I encourage people when they can to try to get into Antitrust Magazine online or another one of the ABA publications. But what tends to be much easier is writing for a newsletter, a committee newsletter, or something like that is not quite as high profile as an article in the Antitrust Law Journal. And if you can start out by writing a couple of good pieces in newsletters, then folks within the section will realize that you're not a complete idiot, and you will have greater opportunities to publish in one of our more prestigious publications.
And I should just say for listeners, when John is talking about the section and committees, he's referring, of course, to sort of the work that the antitrust section itself does to develop talent and allow them opportunities.
Yes.
Let me just also ask you something that follows up from that. So, in your book, apart from sort of the importance of writing and just thinking about antitrust, you do talk about your involvement in cases like, I guess, Sewell, Visa, and Pepsi, and you highlight those cases as being sort of important milestones in your career development. And so I just wanted to ask you, so what would you think are the features of a career-defining case or cases? Like, what makes them special? What makes them move the needle, I guess, as people move ahead in their careers?
That's a really good question. I think one of the factors is getting a published decision. Without a published decision, there's nothing in the books to memorialize the case. Now, if you win a case before a jury and there's no decision afterwards, that's thrilling also. But in terms of contributions to our profession, I think getting a published decision is important. And a lot of my career was moving for summary judgment and getting summary judgments. And in those cases, you do get, a written decision. Post Twombly, you have motions to dismiss that are far more regular than they used to be. And, that also gives you a published decision. So in the cases that you mentioned, Sewell, there were a number of published decisions. The district court issued a few, including one accusing us of malfeasance by filing papers that were too voluminous, even though it was our adversary that was actually guilty for that. He blamed us all. So Sewell, there are a number of published decisions. These are very important published decisions in the district court and the Second Circuit, and Pepsi, very significant decisions from Judge Prescott in the district court and the ruling by the Second Circuit. Those cases, which don't come around that often, but if you want to make a dent in the profession, getting a published decision is the best way.
Okay, switching gears now, let's focus on something I was curious about, which is the writing process itself, writing your memoir. And now there's not a lot of personal information in this memoir, no great behind the scenes gossip, although you do name names. And generally you speak positively of most of the people that you mention in the book. But how did you remember everything? How did you decide what to include, what to keep out? And do you consider the book to be kind of a legacy for your juniors in the profession or for your family? Do you think you'll ever write a more personal memoir?
So I wrote the memoir for myself. I had a long career. I wanted to put it down on paper. It was made a lot easier by the fact that as I had big cases, I would make a point of making hardbound volumes, including the briefs and other significant papers in the case. And that made it much easier to go back and make sure I was accurate in talking about the various cases. So that was important. How did I decide which to include? That's hard. I think I included all the most significant cases, including things like Plantronics, which was not a happy experience for me, Bizarre Voice, which was a victory for the Justice Department against me, which I continue to believe was wrongly decided. But I wanted to make sure that it was fair and balanced, not in the Fox News sense, and that was my objective.
I mean, one thing I thought that was quite touching about, I guess, what you were able to pull out of your files. I wonder if it happens today. Were the letters that you included from lawyers on the other side of cases commenting positively about your work and just saying how well you've done, even when you were reasonably junior? And I'm not even sure that that happens so frequently nowadays. Certainly not in correspondence and stuff. So that was really touching.
So those were all pre-email. So these days you might get an email, saying, nice work. But I made a point of keeping a scrapbook, and I put, letters like that in a scrapbook, newspaper articles about the cases I was working on. And going back to Alicia's prior question, all of that made it much easier to write the book.
It seems like you have a lot of paper in your life. All these bound volumes. Where are they now? Are they at home or are they still in your office?
They're in my office. I wish I had room for them in my apartment, but I don't. Even though I'm retired, the firm is letting me keep an office, and I go in once or twice a week. So I make sure that my bound volumes are still there.
Wow. Well, it might be too late for me to start any kind of archive like that. I'm afraid I tossed so much. I'd have to recreate every file from Pacer or something.
And which is doable, by the way. But when you start out in 1976, there is no Pacer, and things are not online. But my first big case was the FTC versus Coca-Cola exclusive territories case. That was a very big case, and I had all the briefs from it. And this was the first bound volume I made, and I looked at all this. I said, why not make a bound volume? The corporate people do that on every deal. This was a bigger deal than the corporate deals. Let's put it in a hardbound volume, and that's what we did.
Well, I see two interesting lessons to be learned, which is if you're a busy, active litigator, there's no reason you can't start documenting your work in the same way and save it up for 40 or more years. But also, if you see somebody doing a good job, whether as co-counsel or a junior lawyer on opposing counsel, do take a minute to write that letter. I remember seeing letters like that back in the day. I'm not sure I ever took time to write one, and now I realize that was probably something I should have done. So let's bring that tradition back.
Yes, I agree.
I'm right with you on that.
Jon, here's one thing. Looking back sort of on the records, and obviously your briefs sort of contain your information about sort of the big cases, but do you, looking back, do you see a shift in the balance between private litigation and sort of agency proceedings over the years? And how would you maybe calibrate their relative impact on sort of shaping antitrust?
So when I started out, which was in the Carter administration, there was some aggressive enforcement by John Shennefield and later Sandy Litvak. And Sandy actually brought the first criminal vertical price fixing case against Cuisinarts. So, there was pretty good intervention then. It was not crazy. I thought both Sandy and John did a really good job. And I got the opportunity actually to serve with both of them on the Modernization Commission. But then, after President Reagan was elected, government enforcement really reached a nadir. And over the course of the 1980s until George Bush came in towards the end of that period, there was really very, very little government enforcement. Lloyd Constantine, who was the New York State head of the Antitrust Bureau then, brought a number of cases, but it was nothing like you would see, in a normal administration. So during that period, private litigation became much more important. But also at that time, the courts were moving rightward also. And so private litigation, although it was, far more substantial than what the agencies were doing, started running into some roadblocks, particularly after the Matsushita case in 1986 made clear that, Poller was no longer good law and that summary judgment was okay in antitrust cases. And then we have Judge Newman's statement in the Pepsi opinion saying summary judgment is particularly favored in antitrust cases, 180 degrees opposite of Poller against CBS.
We're just about out of time. So we'll ask Jon a question that we've asked many, many guests. Tell us something interesting or unusual or unexpected about himself that is completely outside of his professional career.
So there's a lot to say. The most important of all is that I have two grandsons, Skylar, who is a little more than 4, and Noah, who is 7 months. So that to me, is the pinnacle of life. Having said that, in terms of things that I did, I take great pride before the car accident I was in some years ago on being a great softball pitcher. During the 1980s, I was playing for Lord Dan Lord in the Lawyers Softball League. And in the final tournament to determine who was going to be the winning team, it was us against the Antitrust Division, the New York office of the Antitrust Division. And I shut them out 2-0, and that's one of my great pleasures in life.
Making history again.
This I did not know.
Yeah, that's a good one. And moving into the final portion of our episode, we're going to play a little game, Jon, called The Curious Hat.
And now it's time for The Curious Hat!
The rules of the game could not be more simple. I'll ask Subrata to select a random question from out of the virtual hat. It will be a surprise, so take it away, Subrata.
All right, Jon. Favorite band and how many times have you seen them live?
Well, that is the easiest question that one could ask. It is the Rolling Stones. I've seen them 17 times, starting in 1972 and ending, hopefully not ending forever. I hope they come back and play again. But I saw them twice in May of this year with, my good friends and my wife and my daughter. And I'm a big fan of the Rolling Stones. Obviously.
You're not a big fan. You're a super fan.
Super fan.
A mega fan. That's great. Well, thank you so much, Jon. I recommend your book to all the antitrust nerds out there. It really is a fun read, particularly for antitrust litigators, because you really do get into the nitty-gritty of all the cases. Thank you, Subrata, for being a wonderful co-host. Thank you to listeners. Tune in for the next Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.